Welcome to This Explainer. Today, we're stepping right into a smoky 1960s English boardroom to unpack a truly classic piece of corporate legal drama. This isn't just some dusty textbook story. It's a cinematic clash over agency, power, and what happens when the lines of authority and business get hopelessly blurred. We're going to explore the landmark case of Freeman and Lockyer versus Buckhurst Park Properties, which is a case that quite literally changed how we view corporate contracts. Before we even hit the courtroom, I want to pose this core dilemma directly to you. If someone acts like the boss, they walk the walk, they talk the talk, and they make the big deals, are they legally the boss? As we're about to see, the answer to this question isn't just some game of semantics. In the corporate world, millions of dollars can hinge on exactly how this is answered. Section 1. The Buckhurst Park Boardroom. So picture this. It's 1960s England. Property development is absolutely booming, and Buckhurst Park Properties wants a piece of the action. Their board consists of exactly 4 individuals, just 4 people steering the entire ship. But here is the critical flaw in their corporate governance. They never actually sat down and formally appointed a managing director. So they had the boardroom, they had the paperwork, but no official captain at the helm. Now, what's really interesting about this slide is the sheer gap between reality on paper and reality in practice. On paper, no formal managing director was ever appointed, period. But in practice, one specific director, a guy named Kapoor, simply stepped right into the vacuum. And with the full knowledge of the other 3 directors, mind you, he boldly took the reins. He regularly acted as the managing director, making executive decisions and just running the show anyway. Section 2. The unpaid architects. Let's walk through exactly how this unfolded chronologically. First, the property company is formed with its 4 directors. Second, Kapoor takes it upon himself to act as the managing director. Third, Kapoor confidently goes out and hires an architectural firm, Freeman and Lockyer, to prepare extensive plans for a new estate development. The architects do what they do best. They draw up the blueprints, put in all the hard work, and reasonably believe they're dealing with the authorized boss of the company. But then we hit phase 4. The architects submit their invoice, and suddenly the company slams on the brakes and outright refuses to pay them. Section 3. The company's defense. So what was their excuse? Well, their defense relied entirely on a technicality. Buckhurst Park Properties completely dug their heels in, arguing that Kapoor had no actual official authority to hire Freeman and Lockyer in the first place. They essentially pointed to their corporate charter and said, look, we never appointed him, so this contract is his problem, not ours. They actually tried to use their own internal administrative failure as a shield to get out of paying their bills. Which brings us to the boiling point of this drama. Can a company legally refuse to pay if the director lacked official authority? Think about that for a second. If you provide a massive service to a major corporation just because one of their executives hired you, can that corporation later pull out a piece of paper and claim that executive wasn't actually allowed to sign the contract? Section 4. The court's ruling. Obviously furious, the architects sued, taking this entire corporate mess straight to a judge. To solve the puzzle, the court leaned on a vital legal concept, apparent authority. It is also sometimes called ostensible authority. This kicks in when a principal, which in this case is the company, conducts itself in a way that leads a reasonable third party to believe an agent has authority, even if they lack the actual paperwork. Because the other directors totally knew Kapoor was acting like the boss and just let him do it, they created the appearance of authority. And this brilliantly illustrates the judge's exact logic. The court held that actual authority and apparent authority are quite independent of one another. Basically, it doesn't matter what your internal documents say if your external actions are out there telling a completely different story. Sure, Kapoor may not have had actual authority, but the company's own conduct gave him apparent authority. The court ruled in favor of the architects and forced the company to finally pay up. The absolutely crucial takeaway for any law student or business professional is this: apparent authority can bind the principal. If the principal creates the appearance of authority, they are legally bound by the actions of that agent. You absolutely cannot silently watch someone act as your managing director, reap all the benefits of their deals, and then cry foul the second the invoice arrives on your desk. This case remains a total cornerstone of agency law, and it completely shifted how businesses have to manage their representatives. Which leaves us with a critical thought for the modern business world. Next time you sign a contract, do you truly know who has the authority to bind the company? It's a great reminder to always check the fine print, for sure, but more importantly, to look closely at the actions of the people sitting across the boardroom table. Thanks for joining me on this explainer, and keep asking the tough questions.